Okay, Maximo, Brad will continue to let people in as they join the meeting, but I think that you guys can get started whenever you wish.
Okay, wonderful, wonderful. Okay, and I go first, right? Yes. Okay, good morning, everyone, or good afternoon, or good evening, wherever you are, around the world. My name is Maximo Langer. I am president of the American Society of Comparative Law, and I would like to welcome you, everyone, to this 2021 annual meeting of the Society. Thank you so much to all of you for being here. Unfortunately, the idea for this annual meeting was to have an in-person meeting, to have our usual annual dinner, to be able to chat and see a good old and new friends in the hallways, etc. But once again, the pandemic has kind of interrupted or disrupted our plans. And here we are again for an online conference. Let me apologize. I am in Los Angeles. There are gardeners in the back, blowing leaves and the like. So, if there is some background noise, please know that it's that. We, despite being online, because again, this we thought was our only safe option for this year, we actually have an excellent program. The topic of this year's meeting is the internationalization of comparative law, an excellent topic suggested by the University of Wisconsin. Within this program, we have a plenary panel on this topic of the conference, internationalization of comparative law, that is taking place right after this opening. We have a hot topic panel on COVID and legal trajectories across the globe, continuity or transformation, that it's scheduled for tomorrow, 12:45 p.m. Central Time, and 19 concurrent panels on a variety of comparative law topics, including the main topic of the conference. Overall, we have about 80 speakers and about 400 people registered. We also have, for a second year in a row, our YCC, our Younger Comparativist Committee annual conference, back-to-back with the American Society of Comparative Law annual meeting, that will take place after our annual meeting is done, right? Our annual meeting is scheduled for today, Thursday, October the 21st, and for tomorrow, Friday, October the 22nd, and then on Saturday, October the 23rd, we'll have the annual conference of the YCC, our Younger Comparatives Committee, that has a plenary on the situation in Afghanistan, 6 concurrent panels, adding another over 30 speakers. So overall, we are talking about over 110 speakers presenting their work in 3 days. This is truly one of the main comparative law fests around the world every year, and we are very proud and pleased with that. For the people presenting papers, let me also say that the Wisconsin International Law Journal would welcome submissions for their online journal. And if any of you is interested in that possibility, just go to the website of the conference, and there you will find a link, right, to get more information about that. Before we officially launch the conference and we move to our substantive program, let me thank a number of institutions and people. First, I would like to express my deepest gratitude to the University of Wisconsin Law School, including a couple of centers that have sponsored this conference, the East Asian Legal Studies Center and the Global Legal Studies Center. I would like to also thank the Pyle Center at the University of Wisconsin, that I know has been crucial in the logistics of the conference, in putting this conference together. And I would like also to thank a number of individuals, including Dean Daniel Tokaji. Thank you so much for your support to this conference. Director Sumudu Atapatu, Professors Jason Yaki and Alexandra Huneus for all their hard work in putting this annual meeting together. It's been challenging, like everything else in times of COVID, we thought we were going to go in person, as I was saying. We ended up doing it online, and the University of Wisconsin, as the world-class university as it is, you know, met the challenge with seamlessly, right? I mean, without any problems, and we are truly grateful to them for that. Let me also thank the annual program committee of the American Society of Comparative Law for all their work in the organization of this annual meeting. The members of this committee include Padidea Lai, Nuno Garoupa, Maggie Lewis, Fernanda Nicola, Sang-Jung Cho, and the chair of the committee, Francesca Vignami, has done lots of work for this conference, and so I am very grateful also for her leadership in that regard. Let me also thank the YCC, the board of the YCC for putting the YCC conference together. Antonia Baraya, Vera Korzun as co-chairs of YCC, Rita Scotti, Sarah Ross, Claudia Haupt, and on the University of Wisconsin Law School end of the YCC conference, let me thank Professor Joshua Braver. So without further ado, I'm going now to turn it to Dean Tokaji. Thank you so much.
Well, thank you so much, Professor Langer, for kicking us off in such splendid fashion. I'm the dean here at the University of Wisconsin Law School, and let me begin by, without repeating, extending and amplifying the many thank yous that you just provided. We're very grateful, first of all, to the American Society of Comparative Law for allowing us the privilege of hosting this wonderful conference. I want to thank also Jason Yaki, who played a lead role in conceiving and planning this conference, along with two other members of our faculty, Alex Huneas and Samudu Atapatu. It is really an honor for me to join in introducing this conference and welcoming the exceptionally distinguished group of scholars who will be gathering here over the next few days. I'm really looking forward to learning from you. And like Maximo, I was really hoping that I would be able to welcome you in person and have the opportunity to interact with you, which is much more difficult in an online format. Sadly, that wasn't the case, but as I look over the panels for the next few days, it's really an astounding group in terms of the breadth and depth of your knowledge. I also really love the theme of this conference, that is how international law and institutions provide opportunities for engaging with and engaging in comparative law. That includes comparisons among international tribunals, how different bodies have dealt with similar issues under different bodies of law. It includes how international bodies deploy domestic law and legal processes, including in the determination of international human rights norms. And it includes various countries' own domestic and legal and political institutions and how they apply international law and international norms within their own systems. It's especially appropriate, I think, for us here at UW Law to be hosting this conference in particular, because it is so deeply connected to our intellectual traditions and ongoing practices here. International and comparative law are areas in which our faculty has extraordinary strengths. Just in this conference, we will have participating, in addition to Alex and Jason, Heinz Klug, Samudu, of course, Mitra Sharafi, Asifa Qureshi-Landis, Kathy Henley, John Onosorg, Josh Braver, as well as Steph Tai, Stephanie Dudwania, Aaron Barbado, Yaron Neely, and me as moderators. I doubt there's any law faculty in the United States with a higher percentage of people who are engaged in comparative and international law. And in addition to the people I mentioned, I'd also note our fantastic emeritus faculty, as well as some people from other departments here at UW-Madison who will be participating in this conference. Crossing national and disciplinary boundaries in our scholarship, in our teaching, is something that we are really very proud of here. It is a part of our identity as a law school. It is reflected in our multidisciplinary strengths, which go back, of course, for decades, as well as our connections to the Law and Society movement. So we are really very proud and privileged to be hosting this conference. I'm looking forward to learning from you all, and we hope that we have a chance to welcome you all to Madison before too long. Thanks so much.
Wonderful. Thank you, Dean Tokaji, and thank you, Maximo, for kicking off this year's annual meeting. It's a great honor for me to moderate the plenary panel. And so I'm Jason Yaki. I'm a professor of law here at Wisconsin. I study international investment law and international arbitration. And I teach in the areas of contracts and international business and trade. And as Dean Tokaji mentioned, I helped organize this year's annual meeting. And so I'm thrilled to have you virtually visit us. I'm obviously disappointed that the pandemic has prevented you from visiting Madison in person, but please consider yourselves to have invitations to come visit us in the future. And I hope that I can welcome you here at some point. And so I'm really thrilled to moderate what I think is going to be a stellar panel discussion. And so as you guys know, the theme of the conference this year concerns the promises and pitfalls of applying a comparative law methodology, a comparative law sensibility to the scholarship and practice of international law, where we are construing international law broadly rather than narrowly. And so to address that theme, we've invited a quite distinguished group of scholars to offer their thoughts, drawing on their own work and their own experiences. And so I'll introduce the panelists individually in more detail prior to each of their interventions. But for the moment, I would just ask you to note that the group includes quite broad and diverse expertise. And so one of our aims in building the plenary panel was to invite experts who had already wrestled with the extension of comparative law to new domains. And so, for example, we've invited experts on comparative constitutional law, experts on the emerging and really quite dynamic field of comparative foreign relations law. And we hope to draw lessons from those experiences that might be useful to international law scholars and practitioners that are operating in international law's more traditional areas and institutions. And so the format, each speaker we've asked to speak for about 10 or 15 minutes, and our discussant will follow up with several minutes of comments. We will then open the floor to questions. You can place your questions in the chat. I'll be monitoring the chat, and I can rephrase or repeat your questions to the panel, or you can raise your hand and I will call on you and ask you to unmute. And I'll select among the questions I receive as many as I can in our allotted time. So our first speaker is Richard Albert, a professor of law at the University of Texas and a proud Canadian, I think. He directs the program of constitutional studies at UT Austin. Richard's also been quite active in the society. I think he is already familiar to most of you. He's been the longtime editor of the book review section of the Society's journal. He won the Society's award for most outstanding article on comparative law by a scholar under the age of 40. His most recent book on comparative constitutional change has received accolades from near and far. And Richard also takes great pride in his extensive mentorship of junior scholars. So we're absolutely thrilled to have Richard kick off the conference. Richard, the floor is yours.
Thank you so much, Jason, for those kind words and for that warm welcome. I also want to acknowledge Dean Tokaji. Thank you very much for those words of welcome. And Maximo, congratulations to you for leading the Society so well. Thanks to University of Wisconsin for hosting this meeting, and to the Conference Planning Committee. Thank you so much for all the work you've done. I want to single out Jason and Alex and Sumudu in particular. And before I begin my remarks, I want to say good luck to Alex, who's the U.S. nominee to the Inter-American Commission on Human Rights. I'm pulling for you, Alex, as I'm sure all of us are too. And I'm looking forward to hearing from our fellow panelists, a great group. It's an honor to sit on this virtual dais with them. My own research focuses on how we make and how we change constitutions. I'm interested in how, for example, we design constitutions and how we thereafter amend them, revise them, interpret them, and ultimately replace them. And in my research and reading, I've learned a lot about national constitution-making efforts that build a constitution atop a regime of national rights, civil rights, political rights, social rights, for example. But I found that there's not as much that is known about national constitution-making efforts that seek to build a constitution atop a regime of international law, for example, international human rights law. And so in my remarks today, I'd like to invite you to join me in thinking about international law and constitution making. How do constitutions, domestic constitutions, integrate international law into their architecture, into their DNA? And what can we learn about these constitutions? And I think this inquiry can help us advance the theme of this conference, which is internationalizing comparative law. And so the title of my remarks is International Law and National Constitutions. My plan is to sketch 3 different models of domestic constitutional design that seek to integrate international law, 3 different models that reflect 3 different strategies for incorporating the global values of international law in a domestic constitution. And I define these 3 models in terms of their scope and application. So model 1 is a judicial mandate. Here, the integration of international law into domestic law applies to the judicial interpretation of the national constitution. Model 2 is a prohibition on constitutional amendment. And here, the integration of international law into domestic law applies to how we amend the national constitution. And model 3 is a system-wide constitutional command. Here, the integration of international law into domestic law applies to all actors across the board. Okay, so let me tell you a little bit about each of these 3 models with specific reference to a national constitution currently in force. I think the Constitution of South Africa is a good example of a Model 1 judicial mandate. Under this model, the strategy is to incorporate international law into national constitutions by placing onto courts the responsibility for ensuring respect for international law, specifically international human rights. And so how does the South African Constitution seek to achieve this? The answer is found in Section 39 of South Africa's Revolutionary Constitution of 1996. Section 39 codifies a set of mandatory instructions for judges about how to interpret the Bill of Rights in the Constitution. The Constitution itself describes its own Bill of Rights as, quote, the cornerstone of democracy in South Africa. Its rights include the right to life, the right to freedom and security of the person, the right to privacy, codified, the right to freedom of religion, and so on and so forth. Now back to Section 39, I've told you that it gives judges instructions about how to perform their task of judging. Here's what that section says. When interpreting the Bill of Rights, a court, tribunal, or forum must consider international law, must consider international law. There's a difference between how the Constitution requires judges to treat international law versus foreign law. Because although the Constitution says they must consider international law, it says they may consider foreign law. This is an important difference. When judges look to interpret their own Bill of Rights, they have to refer to international law. But they may, if they choose, look to foreign law. This difference is critical to understanding the Model 1 judicial mandate. Section 39 requires South African judges to interpret the many rights in the Bill of Rights with reference to the global law of international human rights. So Section 39 is just one strategy we see in constitutions around the world to require the state to comply with the global values of international law. I've described it to you as a Model 1 judicial mandate. There are two other models I want to put on the table for us. The Model 2 strategy is to prohibit certain kinds of constitutional amendments. This Model 2 strategy incorporates international law into national constitutions by limiting the power of constitutional amendment. How? By prohibiting amendments that violate international law. A good expositor of this Model 2 strategy is Switzerland. The Swiss Constitution authorizes changes to itself both by its own amendment and its own replacement. So at any time, the Swiss Constitution may be amended or replaced legally, consistent with the Constitution. But whether the Swiss Constitution is amended or altogether replaced, the global values and rules of international law must always be respected, because there's a rule in the Constitution that says no amendment made to the Swiss Constitution, nor any new constitution, may violate the global values of international law, including international human rights. Now, there's an interesting twist here, because when the Constitution says that no new constitution may be made in violation of international law, this conflicts with our conventional understanding of constitution making, because we ordinarily understand the power to make a new constitution to be unlimited, unfettered. We refer to this power to make and legitimate a new constitution as constituent power, and it's typically unrestricted. The constituent power can conventionally write anything into or out of the constitution that it creates, ordinarily. That's the conventional theory of constitution making. But in Switzerland, this constituent power is limited, and it's limited by this one rule that no new constitution may violate international law. So far we've discussed two models that national constitutions use to integrate international law into the domestic context. Model 1 applies to the judicial interpretation of the national constitution, and I refer to South Africa as an illustration of this strategy. Model 2 applies to prohibitions on constitutional amendments, and this is illustrated by the Swiss Constitution. Let's now move finally to Model 3. Model 3 is the broadest in its design because it includes strategies and approaches and requirements that apply to all actors and to all actions governed by the national constitution. Under Model 3, all actors must respect international law, and the best illustration that I've found over the past little while of reading is the Constitution of Bosnia and Herzegovina. This constitution is rooted deeply in the global values of international law. Its preamble declares a commitment, for example, to the purposes and principles of the Charter of the United Nations. The preamble also acknowledges its inspiration from the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and also the International Covenant on Economic, Social, and Cultural Rights, as well as other human rights instruments that are really singled out as important in Bosnia and Herzegovina. The very first rule in the Bill of Rights commits the country to ensuring the highest level of internationally recognized human rights and fundamental freedoms. And one way that the Constitution puts this commitment into operation is by declaring that the rights and freedoms in the European Convention on Human Rights will apply directly in Bosnia and Herzegovina. So you have a direct application of an international convention on rights in the country. Not only that, not only will there be direct application of the European Convention on Human Rights in the country, the Constitution goes even further than that because it gives precedence to that convention over all domestic law. So the entire Constitution is built around a commitment to the global values of international human rights. They're all required, all actors are required to abide by these rules. And it's not just the convention that has direct application in the country. There's an entire list of international human rights agreements that have direct application in the country, and it's a list appended in an annex to the Constitution. Over 1 dozen international human rights agreements have direct application in the country. It's quite an impressive and remarkable list that reflects an interesting constitutional design to commit the country and all actors to respecting international law. So that's the Model 3 strategy of comprehensive application of the global values of international human rights law in the national constitution. So to recap, we've discussed how national constitutions incorporate international law into the domestic context. I've introduced you to 3 different models. Model 1, this judicial mandate, which we see in South Africa, is quite interesting, as is Model 2, which is a prohibition on constitutional amendment, which we see in Switzerland. Model 3, of course, we've just discussed this comprehensive command that applies to all actors, all actions governed by the national constitution. It's a permeation, Model 3 is, a permeation of international human rights in every single part of the Constitution and the Constitution's life. Each of these 3 models seeks to do the same thing, which is to honor and respect international law, international human rights, but they each adopt a different strategy to do so. Model 1 strategies are narrow, as they focus on just one branch of government, but they can be effective if applied by a strong court. Model 2 strategies, I think, raise some long-standing theoretical questions about whether it is in fact possible to limit the constitution-making power. And Model 3 strategies, finally, are the most sweeping of all because they apply to all actors and they create a horizontal commitment to international law within the domestic national context. None of these 3 models is perfect, but I think all 3 are worth considering by any country seeking to make a real commitment to international law and its national constitution. I think that I speak for many of us when I say that the global values of international law and international human rights in particular, that's an urgent challenge for constitutional states in our present day. And I think the challenge is that constitutional states have to think creatively. And they have to learn from other states if they wish to find the best way to honor their own international obligations to protect the global values of international law, specifically international human rights law. I'd be curious to know which of these 3 models you all find most appealing and least appealing, and also why. And perhaps there'll be time for that in our discussion later on. But for now, let me close with just one more word of thanks to our conference hosts and organizers, and also to all of you for being with us here today virtually. For now, hopefully we'll have the chance to see each other in person sometime in the future. Thanks so much once again for the invitation to join you today.
Thank you, Richard, for those really interesting comments and for your challenge to us at the end to think about which model we prefer. I have some thoughts. Maybe they'll come up in the Q&A. Our next speaker is Elizabeth Trujillo, who's a professor of law at the University of Houston Law Center, where she also directs I think she's the founding director, actually, of the Initiative on Global Law and Policy for the Americas. I know Elizabeth from our joint work on the Society's sister organization, the American Society for International Law, where we got to know each other quite well, and it's a pleasure to have her as a friend on this panel. Elizabeth was a visiting scholar recently at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, Germany, where she worked on her most recent book, which has come out through Cambridge University Press, and which presents what she calls a reimagination of international trade law through a sustainable development framework. So Elizabeth, thank you for joining us, and the floor is yours.
Thank you so much, Jason, and thank you. It's very nice to see you again after so long. And I want to also thank Maximo and Alessandra and Sulemu and everyone at the American Society of Comparative Law for having me today, as well as the University of Wisconsin for your kind invitation. Before I begin my remarks today, I should clarify that I do not consider myself a pure comparativist. My field is more in the international trade area, and as well as international investment law. However, I have been a long-time participant and friend of the American Society of Comparative Law. And actually, just as a short anecdote, You know, when I first started teaching, I participated in one of the young comparative workshops at the University of Michigan, because I was thinking a lot about this interplay between trade and investment regimes and how social policy norms become part of these regimes. And so I was working on a paper that contemplated these issues. And the discussant told me at the time, you know, your methodology doesn't exactly fit into the comparative law methodology, because it compares systems or regimes rather than national laws to one another. But maybe someday we'll expand that methodology, even though your piece is not truly a comparative law piece. So at that time, I truly appreciated that critique, because it forced me to delve into the differences between international law and comparative law from a methodological and normative perspective. But I also asked myself why I found comparative law methodology so compelling for the inquiries I was making in the trade and investment context. So I was thrilled when I received this invitation to see the fields merge together in the title of the conference, and excited to learn how the Society continues to evolve its definitions and contours of the practice of comparative law. So today I will focus my remarks on the comparative methodologies, primarily one that I have found useful in better understanding the linkage between trade norms and environmental norms, the ways that cross-fertilization between these two camps have emerged, and the results of this cross-fertilization for reframing the trade and environmental linkage through the lens of sustainable development. So I'll begin with an overview of some of the advantages that I find in using a dialogical approach to understanding this trade and environmental linkage. And in using this approach, I primarily draw from comparative constitutional law, and I focus on two main ways in which the WTO adjudication has contributed to the evolution of the cross-fertilization of trade and environment, and why this has been part of the international environmental law framework as well. And second, I'll discuss the role of fragmentation in international law as it concerns the trade regime and its role in fostering enhanced cross-fertilization between the two camps, as well as the role that regional trade agreements play in furthering sustainability goals in the context of the environment. I'll discuss some of the challenges that I find in using a formal comparative law approach to international trade, particularly as global institutions like the WTO are being challenged by a return to nationalism and local policies to solve international policies. However, despite some of these challenges, I'll conclude with a positive note that with some thoughts of the utility of transnational dialogue in shaping policy that works for sustainability and vice versa. So I think it's very important to note that unlike some of the aspects that Richard so eloquently discussed with respect to the role of comparative constitutional law in its context, the WTO jurisprudence truly does not formally engage outside of its WTO jurisprudence or outside of its trade framework. However, over the years, and looking in more detail at some of the dispute settlements in the WTO, it has become clear that trade adjudication has had to engage with non-trade norms, as it considered the way that trade compliance aspects of social policies have taken hold at the domestic level in the form of regulation for areas such as environment, labor, and health. In addressing the trade compliance aspect of these domestic policies, trade adjudicators have had to consider domestic regulatory measures and their possible discriminatory effects of trade liberalization. This is where comparative law methodology is most relevant, I find, for the culture and the language of trade is quite distinct from that of the environmental regime. Terms like protectionist measures are familiar to trade experts and are approached with the assumption that there is a possible hindrance to trade liberalization principles, whereas for an environmental regulator, a protectionist measure would instead be considered a regulatory measure necessary for the public interest. These two very distinct views of domestic policy is at the core of the tensions between trade principles and environmental ones, and the distinction is apparent in the very distinct language used in each regime to describe the same measure. So before beginning our discussion on the utility of comparative law methodology, it's important to note that it's not the common practice of the WTO adjudicatory panels to use comparative law methodology per se, nor to look or to borrow from other legal frameworks or case law from those frameworks in making their own analyses and conclusions on a trade dispute. And yet over time, we have found that WTO adjudicators, as a result in part of the arguments that the parties to the disputes have made, have been dealing more and more with the non-trade legal frameworks in their analyses and reasoning. So in my own work on the application of comparative law principles to trade adjudication, I have found that comparative constitutional law tools provide an analytical window, a prescriptive approach in which to understand the ever-evolving convergence of trade norms with environmental ones. It is not, though, the methodology of choice in trade adjudication. The more modern comparative methodology that focuses on judicial dialogue has been the approach of choice in analyzing this evolution of trade and environmental linkage, though. This approach focuses on the process of constitutional interpretation and focuses on the dynamic and discursive process of adjudication, where courts may engage with other branches of government. In the international context, a dialogical approach helps us understand the way in which international courts interact with one another and with national courts and/or national regulatory agencies. It allows for judicial comity and fosters international reciprocity of international norms, enhancing cross-fertilization of trade and non-trade norms. And more specifically, the dialogical approach considers the ways different legal norms interact. It highlights the dynamic process of the judiciary engaging with non-judiciary actors. In having to address non-trade norms, such as environmental measures, trade adjudicatory panels have to engage with principles, laws, and regulations outside the trade framework. This has impacted the discourse of trade in concrete ways that have resulted in cross-fertilization of trade and environmental norms. And then finally, a dialogic approach provides a prism through which to see various interactions between trade and environmental issues. In this approach, there's no hierarchy per se, and it, as a result, becomes easy to see a pluralist range of sources of authority for non-trade norms that may be applicable in any one trade dispute. So from the very first trade and environmental case, the US tuna dolphin case, that questioned a US moratorium on the importation of tuna products that may have been fished using the antiquated methods impacting the health of dolphins, trade adjudicators have had to confront environmental measures and consider their impacts on trade. In doing so, tribunals, with a focus on the interpretive capacity of judges, needed to consider the possible procedural and substantive legitimacy of these measures domestically. There are two primary vehicles through which the WTO tribunals have engaged with trade norms. The first is through judicial interpretation. I want to start with judicial discretion in choosing to engage with outside sources of law. That choice has played an important role in the convergence of trade and environmental norms. While the general principles of international law apply to international trade as well, trade adjudicators at the WTO did not necessarily apply provisions of multilateral environmental agreements in their consideration of the viability of domestic environmental measures under trade law. For example, though the precautionary principle is a principle of international environmental law, the WTO appellate body has not adopted it as an established principle of international law applicable to international trade. In one of the early WTO trade environmental cases, the US shrimp case, alleging the illegality under the GATT of a US requirement to use turtle excluder device in fishing for shrimp in order to protect the endangered sea turtles, the appellate body referred to multiple international environmental agreements, including the CITES agreement, since these were raised by the parties. Related to this is the increasing willingness of trade tribunals to admit and then refer to amicus briefs into the dispute settlement. And this enhances cross-fertilization by allowing third-party participation in trade disputes and somehow have external reach into the domestic social policy spaces, like in the area of environmental protection. It also allows for more voices to participate in trade adjudication and to hear different perspectives. Another aspect of judicial discretion that I won't spend as much time on today is the aspect of deference. There are types of trade cases in which the courts have given more deference to domestic policy. And we see quite a bit of it, particularly in the investment side, where some deference to regulatory processes are given. And finally, the trade and environment cases that WTOs have most recently heard have shifted that trade and environmental linkage towards trade and clean energy, highlighting the need for local and national decarbonization policies. Several cases have involved renewable energy schemes, as well as local content requirements, which are generally disallowed because of their discriminatory effects. But again, this shift that we see towards a focus on energy allows for a broadening of that trade and environmental linkage and for more convergence of trade and environmental norms. And second, the interpretive capacity of trade tribunals is an important tool through which trade adjudication dialogues with environmental frameworks. We have seen this in various cases, such as in the US shrimp case, where they expanded the meaning of exhaustible resources under Article 20G of the GATT to include natural living resources like turtles and trees. The early adjudication began with a trend of judicial recognition that trade treaties would have to be, trade treaty interpretations would have to be done in light of environmental concerns rather than despite them. This is also evident in the appellate body's recognition of product production methods, that they may be in fact within the scope of GATT provisions. These early moments of cross-fertilization set the groundwork for the possibility of reconciling trade liberalization and with social policy space needs, as we are seeing today in current trade and environmental sustainability discussions, the work of the WTO Trade and Environment Committee, and other initiatives taking place in Geneva in preparation for the 12th Ministerial Conference later this year, which hopes to produce for the first time in WTO history a formal statement on trade and climate change. And finally, a dialogical approach provides a prism through which to see the role that fragmentation in the trade regime and in regulation have contributed towards cross-fertilization of trade and environmental issues. There's a multiplicity of jurisdictional regimes that have emerged with the rise in regional and bilateral trade agreements. There are multiple avenues for transnational convergence of trade and environmental norms. And the first trade agreements to even recognize the relevance of trade to the environment was the NAFTA, becoming the first regional trade agreement to incorporate it as an environmental side agreement. And the most recent USMCA, which replaces the NAFTA, incorporates an environmental chapter into the trade agreement and expands the definitions of environmental law, encompassing principles of sustainability and other areas of environmental law that were not discussed or contemplated in the original NAFTA. We see other regional trade agreements like the Canadian-European Free Trade Agreement that is actually establishing a sustainable development framework in the context of trade. All of these types of arrangements allow for several avenues for increased transnational dialogue on issues related to regulation in the areas of environment, but also energy and trade. It becomes evident that fragmentation lends itself to multiple centers of dialogue where trade regulators and environmental ones may engage and collaborate on issues concerning both their camps. In this context, a dialogical approach moves away from its traditional focus on adjudication towards broader forms of dialogue through transnational fora for collaboration on regulatory norms. Furthermore, recent regional trade agreements like the USMCA have reduced the likelihood of dispute settlement altogether in favor of increased forms of dialogue through more consultations, more formalized forms of collaboration of standards among countries involved in those regional trade agreements, so that adjudication becomes less necessary. In sum, a dialogical approach towards understanding the trade and environmental linkage has allowed us to unveil the underlying currents that have contributed towards this convergence. It also has resulted in a better understanding of the opportunities that fragmentation creates for trade and environmental convergence, so that trade may evolve to be the promoter of environmental sustainability and not the obstacle. Ultimately, my hope is that we shall see an emerging shared environmental discourse between trade and sustainability. There are several challenges in using a comparative law approach in the context of trade, though. First, comparative constitutional law approaches draw their theoretical strength from the underlying presumption that a constitutional form or identity exists, one that preserves a system of rights and duties for the relevant society. Many have written about whether the WTO regime creates a constitutional ethos. At the very least, it has exhibited aspects of a constitutional framework through its treaties, governing structure, and historically strong adjudicatory capacity. The beauty of the dialogical approach, from my perspective, however, is that it is grounded in the process of judicial review rather than in a constitutional ethos. This begs the question, though, whether it will be at all relevant in the current climate where global institutions are being undermined and a return to national identities is dominating any sense of a globalized society. The dysfunction of the crown jewel of the WTO, the appellate body, certainly puts into question the capacity for judicial dialogue and trade and non-trade convergence. Furthermore, as environmental regulation becomes less centralized and informal norms and standards become more relevant, connecting environmental regulatory processes to the public interest becomes more tenuous. However, though a dialogical approach may have its origins in the strength of adjudication, there are many entry points for dialogue in the trade and environmental linkage, many of which have been explicitly formalized in recent regional trade agreements. The convergence has evolved and opened the door for various avenues, formal and informal ones, for a reframing of the trade and environmental linkage towards one that allows each framework to reinforce the other, and where a shared trade and environmental discourse may foster universal principles for environmental and economic sustainability. Thank you very much.
Thank you so much, Elizabeth, for those really interesting remarks. I think that they highlight the great sort of potential for comparative law to inform international legal practice, especially as you pointed out. The system is so complex and fragmented, it presents multiple potential or actual conflicts of jurisdiction or conflict of laws, which really is sort of the core of traditional comparative law approaches. So thank you for your intervention. I just wanted to say quickly that my computer crashed during your talk, and I have rebooted, obviously, but if it crashes again and there are any issues, Alex, can you please stand by, ready to take over? Thank you. So our next speaker I am pleased to present is Kurt Bradley, who's a professor of law at the University of Chicago, just starting this year. I am a bit upset with him for leaving my alma mater of Duke, where he served with great distinction for probably about a decade. Kurt is the leading scholar of US foreign relations law. He clerked on the US Supreme Court. He served as a legal counselor in the US Department of State. He was the reporter for the fourth restatement of foreign relations law of the United States. And he's published widely in top law reviews and is the co-editor of the American Journal of International Law. We are exceptionally pleased to have you join us today, Kurt. Thank you.
Thanks a lot, Jason. Thanks to the Society and to the University of Wisconsin for inviting me to participate. It's a pleasure for me to do that. I'm a bit of a newcomer to comparative law, and so I'm here as much to learn as to offer what I have learned. Most of my forays into this field have been in an emerging field. I say emerging in the sense I'm trying to get it to emerge, a field of comparative foreign relations law, and I'll say just a few words about what that is. I spent about 5 years putting together a very large volume with many authors called the Oxford Handbook of Comparative Foreign Relations Law that compares and contrasts how nations structure their authority over foreign affairs actions, as well as how they vary in their incorporation of international law into their domestic legal systems. And the structural issues are ones familiar to all of us, including, of course, in the United States, issues like who gets to participate in when you make international agreements domestically. Is it just the executive, or is the legislature given a role? A topic people don't like to think about as much, but it's relevant, and we've seen it in recent years. Who gets to decide when you pull out of treaties to withdraw? Is that, again, just an executive power, or is it a shared authority? Another topic that unfortunately is often with us is uses of military force. How do domestic systems allocate authority over that significant decision? And then in terms of international and domestic legal systems, nations vary a lot in when treaties can be invoked in court, when they're so-called self-executing. Questions of customary international law, whether they have some kind of direct status or more of just an interpretive role. We see lots of variations among different systems. And also what kind of limiting doctrines judiciaries have on their own role in foreign affairs. Are they active players in the foreign affairs realm? Or are they really on the margins? And we see a lot of variation there as well. What I thought I would talk about in my brief time is mainly the challenges I encountered as a newcomer, trying to do serious comparative work and learning from others. And I think these are going to be continuing challenges as this field that I am trying to foster blossoms. I think they're challenges we all need to be thinking about. And I'd be interested in your thoughts and questions as well. 3 types of challenges that I will mention. One is just the great variety of sources that end up being relevant to the topic, that go beyond some of the obvious ones. Second, the very contextual, and I would also say interdependent nature of legal rules in this area that make it quite challenging and I think problematic to study them in isolation. And then, particularly if one gets to prescriptive thinking, there are real questions about what the proper comparators are, and both in terms of countries and in terms of the practices. And I'll explain that because that might be a little bit vague. So here's an obvious point in terms of the first challenge of sources, which is the easiest thing probably to study, and there are really great coding projects on this, would be the texts of national constitutions, to the extent countries have written constitutions, as most do. You can imagine the excitement. You can do great empirical research, both contemporary and over time. The problem is much of foreign relations law is actually not constitutional, or if it is, it's not obvious from the text. In fact, I will even suggest in some dramatic cases, it's sometimes the opposite of the text. And it's a real challenge for researchers. And I'll use the example of the United States in a minute, because basically a lot of our foreign relations law looks like the opposite of the text. But even before you get to that point, a lot of foreign relations law is statutory, administrative, and then judicial precedents in some countries in particular. But most challenging would be some foreign relations law or relevant material is actually more of a kind of a political practice. Understanding the norms and practices of government institutions actually does a lot of work in understanding how systems work. And that is super hard to actually study from the outside. Certainly coding national constitutions is not going to get you anywhere close to understanding the actual normative practices of institutions. But I think it's quite significant, and I'll give an example in a minute. Just a couple of examples from the book. I could give you many. So Japanese Constitution, you look at it, you might think, well, sort of like the US Constitution. To make a treaty, you have to get the approval of the legislature, the Diet. It turns out, like the US, they actually have things called executive agreements that don't necessarily go to the legislature, not obvious from the text. How do we know which ones go to the legislature in Japan? Well, in the 1970s, a foreign minister, Ohira, put out kind of a promissory set of principles that the government, the executive, would follow, and kind of certain kinds of important agreements would definitely go to the legislature, and other more administrative arrangements, for example, would not. And to my surprise, it sort of works in practice. That is, there seems to be a kind of enough trust and good faith among the institutions that it kind of roughly works over time, where they don't think there's too much cheating. You would not know about this allocation of authority by looking at from the outside of the text, for example. Another example, Great Britain. So we know parliamentary approval not required to make treaties in the Commonwealth, many Commonwealth countries, including the UK. But it turns out for about 100 years, there was a convention, that is a political practice, of the executive being expected to lay and table before the parliament for a period of time, treaties before the executive acted upon them. So at least the legislature would have some notice, maybe you could raise complaints, etc. And it's actually finally codified. That's kind of an interesting side story. Recently, it was codified in a statute. They decided after many decades of it being a mere practice that it'd be better to have it as a statute. But again, not at all evident from the unwritten constitution of the UK. Now, the US Constitution is probably maybe one of the most vivid examples of my point. If you look at our text, how do you make international agreements? Oh, well, you've got to go to 2/3 of the Senate. Well, that's super hard. In fact, it's almost impossible today because of partisanship, and it doesn't happen. We basically have stopped making treaties through the one clause in the Constitution about making treaties. It had been down to less than 10% of our international agreements. It may be down to like 2% at the moment of making international agreements through the only process in the Constitution. Instead, we make basically all agreements through executive agreement processes of various sorts, which I won't mention. But again, text is going to be, in fact, quite misleading there. How do we get out of treaties in the US? There's actually no text in the Constitution. The 19th century practice, interestingly, was kind of shared with the legislature, not since FDR. It's basically all been executive for the most part, some controversies, but mostly not. And just the executive just accrued power, imperial presidency. You'd have to understand the practice to know that. War powers, good argument that the founders probably meant for the Congress to control any non-defensive uses of force. Not true since World War II. We hear about them, unfortunately, all too frequently. The executive uses force on behalf of the United States, often without legislative involvement. It's just a practice. Inside the United States, treaties. It looks like the US purposely rejected the British tradition of requiring parliamentary implementation of treaties. We have a supremacy clause, treaties are the supreme law of the land, very monist, for those of you who know that term in international law. Maybe that was true in the 19th century, maybe even early 20th, not true anymore. Most treaties are not given direct effect in the US. They're deemed non-self-executing. How would you know that unless you understood the practice? Customary international law. The text actually seems to say only Congress can bring it in. It doesn't have direct effect. But then there's the common law tradition from the UK, in which maybe customary international law is part of the kind of common law that the courts can apply in relevant cases. On the other hand, we've had massive jurisprudential shifts on the nature of the common law in the US. Hugely confusing story. Weirdly, it was the first big article I ever wrote decades ago on this topic. It is still not at rest. 230 years after the Constitution, we still don't know the answer to the domestic status of customary national law. Imagine being an outsider trying to figure out the answer. Quite difficult. So that's the biggest challenge. What are the sources? How do you get a handle on these things that are not, say, the text of the Constitution without being like a lifelong expert in the country? I have a thought in a second, for at least what I did about it. But a couple of other quick challenges. Watch out for piecemeal study. You study one doctrine in isolation. A lot of things are interdependent with other rules within a system. So just an easy example, to say that Great Britain does not require parliamentary approval for treaties, you better know they also have a rule that those treaties are not given direct effect as a trade-off for not requiring legislative involvement in the front end. And there are lots of examples like that, but also just historical conditions. Why do constitutions look differently? A lot of time it's the time they were adopted. The German and Japanese constitution, for example, were adopted in a very different context than the American Constitution or the South African Constitution, which Richard had mentioned, adopted more recently. All of them have their own historical antecedents and generators that help explain the choices that are being made. And it can be hazardous to generalize across those time periods. What did I do in the Oxford Handbook? Try to address these some of these challenges. One thing we did was we had a mix of country-specific chapters from real experts in those countries in the same section of the book with people who wrote general, theoretical, empirical accounts. And we had them interact on multiple occasions so that the generalists really were understanding the references that they were making. And I thought that dialogue was kind of essential. The other thing we realized is, another temptation we have, and I think a good one, is the whole world is our studying grounds, which is exciting, 193 countries. And for some kind of projects, that's absolutely right. If you want to know historical trends, it'd be good to see what's happening in all the continents of the globe and how things have transcended across different regions. Historical trends might deserve big and empirical studies and the like, but the more you get prescriptive, the more it gets complicated. If you want to figure out whether, say, there's a trend among democracies to try to increase legislative involvement in foreign affairs in response to various world events, it's not clear who you're looking at. You might narrow it down to democracies. You might even focus on some that have kind of similar foreign affairs portfolios if you're trying to draw prescriptive lessons. There are real questions about which ones make sense to study, particularly if you're trying to figure out suggestions for reform. I do think, by the way, it's easier in the statutory realm. I think if you want to pass a new sovereign immunity law or something, you would find easy comparators of nations that maybe have done some work on it and see whether some of their innovations might work well in your system. So I think there are opportunities, but even there, you'd be picking out examples that seem to fit as opposed to just kind of generalizing across the globe. And I really think it depends on the purpose of the inquiry. And I think also it's important to draw lessons about what not to borrow. I'll pick on the United States. I'm not sure that constitutional drafters should take hearty lessons from the US experience on a number of areas, but say the treaty clause. Why require supermajority consent to make treaties? Well, I'll tell you, the US did it for very specific reasons in the 1780s, and partly related to slavery, partly just related to more just general sectional differences between the North and the South. And that just may not generalize or may be bad. And it makes it very hard, particularly with partisan politics, for the US to have its constitution actually work in the treaty making area. And there are lots of examples, I'm sure we could add to that, of things not to do. So sort of, and I'll just conclude with this, my takeaway is I think forays into this field really need to be methodologically pluralistic. I'm not denigrating big empirical work, which I think there was a lot of it in the book that I worked on. I think it's fantastic. But I really think things like survey work, which is what I'm doing for a new project that I'm doing on non-binding agreements. I did these big surveys that I've circulated to people in foreign ministries and elsewhere, that I can have the same survey instrument across different countries. And then for me, very importantly, I'm having a series of conferences in which they talk about what they wrote in the surveys and share ideas so we can actually kind of deeply understand the results and not think we understand just from written text. So that kind of dialogue and qualitative survey and other material, I think, is a necessary supplement, at least in this area of comparative law. Thank you.
Thank you so much, Kurt, for the interesting talk. To me, I was very pleased to hear you talk about foreign relations as political practice as much as, or if not more than, legal practice. And I think that if I can add a challenge to your long list of formidable challenges, I would say that it really forces us to be comparative bureaucracy scholars. And given the sensitivity of foreign relations, we're often limited to archival research from the past, which makes us, we have to be comparative historical bureaucracy scholars in some sense to understand the bureaucratic fights and practices that are a big part of this field. So kudos to you for taking this project on. Our next speaker is Mila Verstig, who's a professor of law at the University of Virginia. She directs the Center for International and Comparative Law and also the Human Rights Program. Mila is a quite prolific scholar. She has an amazing record of publications in top political science and legal journals. Her work focuses on comparative constitutional law, public international law, empirical legal studies. She was recently an Andrew Carnegie Fellow in 2017 in support of her work on comparative constitutional law. And so we are thrilled to have her as the final of our 4 panelists. Mila, the floor is yours.
Great. Thank you so much for having me. Thank you to the organizers for organizing this conference, for putting together this panel. I'm very excited about this topic, right? Thinking about applying comparative methods to international law, because at first, an uninformed response to the enterprise is maybe something like this is an oxymoron, right? Comparative international law, right? Because the idea is that international law is supposed to be the same across different legal systems. And one may think that the whole point of concluding international legal agreements is that all countries agree to the same thing, right? But of course, we also know that once we look behind the surface, that is often not the case. So there's 2 things I wanted to talk about today. So first, when we're thinking about applying comparative methods to international law, what methods are we really thinking about? And then second, what does comparative inquiry of international law look like? What is kind of the realm of possibility? So on the first, right, when thinking about applying comparative methods to international law, what do we mean by the comparative method? So of course, comparative law, traditional comparative law, if I may call it that, has seen a lot of debates over how to compare, what to compare. One big debate is what should be really compared to what, or really a debate over the functionalist method in comparative law. Is it okay to look for functional equivalence across legal systems? And when we do so, do we maybe miss out on important differences across systems? Or more broadly, we have debated the question whether we should be looking for similarity or differences, right, in a comparative enterprise. So I don't have time to go into all the different comparative law methods debate, but I wanted to put on the table that there's another methods debate that is taking off, especially in comparative constitutional law, and maybe to some extent in comparative foreign relations law, because Kurt referred to it as well, which is really the question whether we should incorporate social science methods in the study when we're doing comparative analysis, right? So in comparative constitutional law, there has been a lot of attention for thinking about how do we make causal claims about constitutions and constitutional law, right? What explains why certain countries make certain choices? What is the effect of certain constitutional choices on practice, or and so on? And this requires, thinking about methods. So for example, in comparative constitutional law, we've been having a lot of debates about case selection. So one can make causal claims through careful selection of cases, but we really need to think through what are appropriate cases if one wants to do so. It has also required us to go beyond what was the traditional canon of comparative constitutional law. We used to always study the same handful of countries in the global north, and we kind of stopped doing that, right? We've realized it's important to add more countries if we were thinking about causal inference based on true case studies and so on. So our cases have really expanded. And as part of this wave, we've also seen a movement of large N constitutional studies, that is researchers using statistical techniques to analyze constitutional texts. So there have been a number of projects, as Kurt referred to, quantifying the text of constitutions and analyzing that. So for example, just to illustrate the kind of work in this vein, so the book that I just published with my co-author Adam Chilton is called How Constitutional Rights Matter, and it combines case studies with statistical methods to say something about or try to answer the question, does enumerating rights in the Constitution actually make a difference, or does it actually change government behavior in some way, right? So when I think about where comparative constitutional law has gone, and also where comparative law, traditional comparative law has gone, I think both of these methodological debates are important and useful to consider when we're thinking about applying comparative law to international law, right? So we should incorporate insights from traditional comparative law, always ask ourselves whether we're comparing the right things, whether we're looking for similarities or differences and so on. But we should also think about incorporating these kinds of interdisciplinary methods. So, and I kind of feel that in some ways, there's always a lot of skepticism about this. And in part, I feel that comparative law has gotten off to a little bit of a rocky start with interdisciplinary methods, because I think when many people think, especially about large N comparative studies, we think about the legal origins literature, which is coming out of economics and uses these very broad classifications, civil law, common law, and then it explains a lot of things today. And I mean, this literature has been much criticized for reasons that I don't have time to go into. But I do think, if I think about comparative constitutional law, there's actually been some really fruitful collaborations between political scientists and comparative constitutional lawyers, and where we really can also get at the legal nuances and apply comparative methods. And I think for comparative international law as an emerging field, I can see similar alliances between political scientists and international legal scholars, and also drawing on international relations, right? International law and international relations have also long worked together. Okay, so that's my thoughts about the methods. Then the second point I want to address, what would this look like, right? So assuming we're going to do this and setting aside the methods for a second, what kind of questions are there to answer? And there's a lot, but I wanted to flag two, I guess. So a first type of inquiry, which I think is going to be part of this field, is how does what seem to be the same international legal rules work out differently in different settings, right? So pretty much every country has ratified the International Covenant on Civil and Political Rights. But we see that there is differences in interpretation. To just mention one high-profile example, the US and Israel claim the treaty does not have extraterritorial application. Many other countries say that it does. So what explains these differences? I mean, the text is arguably ambiguous on this. So I think this is a typical comparative international law inquiry. Likewise, we can ask, are there differences in application? Are there differences in interpretation? Maybe a bit more vague, but do we see different stances or approaches towards different bodies of international law in different parts of the world? And so methodologically, I think it's worth reflecting from a comparative law perspective that this is an exercise of looking for differences. So instead of assuming that all these international legal rules are the same, we are going to look for how they are different and how they work out in different settings. So that's, I think, one type of inquiry. A second type of inquiry is to explore how different legal systems formally deal with international law, or in other words, what is the relationship between the domestic legal order and the international legal order, or really maybe the question of what Kurt calls for comparative foreign relations law. I always think it's whether or not you call it foreign relations law is itself an interesting comparative question, because I think in countries where the international legal and the domestic legal order are usually seen as one, scholars are not used to thinking about this as a separate field, but that's to the side. But I mean, this is a different type of inquiry, right? So this is here we assume that all states have some rules on how to deal with international law and their domestic legal order. And then they have to, and then we're going to look to how these rules are the same or different, or try to map what they are. So for example, if you ask the really simple question, how do treaties apply in domestic law? You find that there are roughly two broad approaches, right? Some states apply the treaty directly. These are what we call the monist systems. And then others require the treaty to be implemented by legislation. These are the dualist system. Of course, then you get into all the exceptions and further rules, right? If they're applying directly, what is the status vis-a-vis ordinary law? Are there exceptions for non-self-executing treaties and so on? But the basic world can be divided in two, if you ask me, right? And that's much more of a traditional comparative law inquiry. Most comparative lawyers feel fairly comfortable probably to do this kind of inquiry. So within this broad second approach, I wanted to share some of my experience from a research project that I've been doing with my colleague at the University of Virginia, Pierre Verdier. So we have started a big data collection project. It's a large M project, looking at the relationship between domestic and international legal orders for about 120 countries from 1789 to today. And what we did is for each country, we basically wrote a long memo where we tried to answer a set of standardized questions, some 50 questions. How do countries ratify treaties? Is Parliament involved? Can they enter reservations? Do they have workarounds in the forms of executive agreement? What is the status of international law in the domestic legal order? What's the status for treaties, for custom, et cetera, et cetera? Answering these questions was not easy. I mean, we did not just look at what the Constitution says, and I completely, wholeheartedly agree with Kurt that constitutions are remarkably useless to study when you're interested in foreign relations law. So what we did is we started with the Constitution, but then we looked at organic laws, court cases, executive orders, but often it's really a matter of convention and practice. So we end up reading casebooks from these countries, whatever the foreign relations law casebook is, although in many countries there's no casebook that's called foreign relations law, just FYI. But for the countries where we did not speak the language, we really relied on local researchers. So we collaborated with local experts to get our answers to these questions. We've been doing this since 2014. We're still not done. It's a lot of work. Like every country questionnaire is multiple dozen pages long because it's not easy to find this stuff. But what we then did, we then quantified these reports and turned them into some 50 plus variables. and have analyzed those, right? But it's important to emphasize we didn't just look at text, although I do have some reflections on the project that are a bit along in the same vein as Kurt's. But I'd like to think of this project, maybe I'm wrong, as one where we incorporate both the social science methods and well as sort of the tradition, the methodological insight from more traditional comparative law. So 3 insights that I wanted to share with you, and then I'll end, based on this project that I think are worth reflecting on more broadly, that have more broader insights. So first, we were struck by even how outcomes were often the same. The legal technologies that were used were often different, right? This is the point that Kurt made as well. Sometimes this was in the Constitution, sometimes we found organic laws, sometimes we found conventions, and so on. And I think it's worth reflecting, or something that we've been thinking about, is does this matter? How states get there, right? If they ultimately do the same thing, does it matter that this is done by the Constitution or by ordinary law or through conventions? So interestingly, international law doesn't care how states implement international law, right? The Vienna Convention on the Law of Treaties only says you can't use domestic law as an excuse for not upholding your treaty obligations. But basically, international law doesn't really care. There is probably a type of comparative law that also doesn't really care, right? We're interested in functional equivalent. These countries are doing the same thing. It doesn't really matter what legal tools they use. But I think maybe my hunch is that the who, in addition to just the what, or the who and the how, it actually may matter. And we have this information in our country memos, but we did not initially quantify this because we were, as international lawyers, maybe not that interesting in how this was done. But I guess that leads me to a second insight. So looking at this data, one of the things that struck us the most is how much colonial origins matter to the states. And I wanted to mention that because Alex asked this panel to consider whether comparative approach to international law gives us more room to think about how the global South shapes and approaches international law. And at least when it comes to this part of the inquiry, right, the relationship between domestic and international law, colonial origins are tremendously important until this day. And second, what we often found is that this was often this is often a court-led development. So it's very common for a pattern that we say was the independence constitution of a new country is silent on how how international law is received in domestic legal order. And then we found court cases that saying, well, we're a common law country, so obviously treaties need to be incorporated through domestic law, right? So we often found that this was judge-led, and that when we look at former British colonies are basically like the UK, former French colonies are basically monist. But when we saw innovation, it was almost always through constitution making. So it was constitution makers that departed from inherited patterns. So that brings me again to the insight that maybe we should just not look at the what, but also at the who and the how. Okay, final insight, and then I stop. I think for an exercise like this, I do think we still have to continue to reflect on when we think we're looking at the same thing, are we actually capturing the same thing? I mean, this is a question that all comparativists always ask themselves, but I think even after all our digging into conventions and what the local experts say, are we really still capturing the same thing, right? So for example, we found that some countries give customary international law a status higher than the Constitution or higher than ordinary legislation, but really we should be asking ourselves, what do they mean by customary international law? How do they understand customary international law in the first place? Is it even applied, right? There are some countries that rarely ever use customary international law. So those, I think that's where our data is somewhat unsatisfactory. Or for example, we look at whether courts have canons of interpretation to interpret the Constitution or ordinary laws in line with the Constitution, and we found they don't. But maybe Parliament is doing this, right? And we didn't ask that question. So I think we continue to have to reflect on the limitations of an exercise like this, even if we try to go beyond text. Okay, that's all I had to say.
Mila, thank you so much for that. We will now move on to the discussant portion of the panel. And so my colleague, Alex Huneeus, will offer some comments on the presentations. Alex is a professor of law here at UW, and she's also the director of our law school's Global Legal Studies Center. She's an expert on international human rights. And as was mentioned at the very beginning, she is currently the US nominee for the Inter-American Commission on Human Rights, for which we are very proud. Alex, the floor is yours.
Thank you. Can you hear me?
Yep.
Okay. Well, I also want to begin by thanking the conveners of the conference, thanking ASCL for allowing us to host this, which is a huge honor for us, and thanking my colleagues, Sumudu Atapatu, and particularly thanking Jason Yaki, who was the one who came up with this idea in the first place, got us to do it, organized the plenary, and shaped the conference theme. And I hope that my questions and comments that I'm going to give live up to the spirit of that theme as he originally imagined it. And I really just want to make, since I didn't have papers, I thought that I would just further the debate by asking some of the basic questions that are motivating this conference theme, which I see as an effort to get the field of comparative law and those who've long focused on comparing legal systems and that whole tradition in deeper conversation with those in the realm of international law who've embarked on this more recently, on this comparative project, very much along the lines that Mila was speaking. Comparative law scholars have since really the 17th, 16th century been struggling with and theorizing how you grasp and compare legal systems. And if we look to this tradition, there's always been particular questions and in a way methods. For example, there's always been an emphasis on the classification of legal systems, of creating typologies of legal families with similar traits as a starting point for analysis. And we saw a little bit of this today, I think, with Richard Albert's presentation. He's really been very rooted in comparative law, and he starts with the creation of a typology. And some of the categories that have been important have been common law versus civil law, Napoleonic versus Germanic, Russian traditions. Something else that came up, democratic versus authoritarian. And then there's a long tradition of writing around this concept of legal transplants, what happens when you have similar institutions and move them from one system to another. They develop in different ways. And this concept mentioned by Mila of functional equivalence. So my first question, some of you have answered this already, but in what way has this tradition of comparative law been an explicit resource for you in your work? And this is more for those working in the international law tradition. I have a different question for Richard, but how has this tradition of comparative law been a resource for you in your work? And if it hasn't been, why is that? And looking forward, how could that interaction between these different, this emerging field in international law and this longstanding tradition of comparative law, how could that interaction deepen, right? And that your answer could be institutional, or we need to have joint sessions of ASCL and ASIL, or it could be more substantive. And in this sense, Richard Albert is a bit of the outlier on the panel because he's so rooted in the comparative tradition and has played a role in shaping it, an important role in shaping it in recent years. And I wonder if you could speak in what ways your enterprise is synchronous with the field of international law, and are there concepts from there that could help your work? And there I can't help but respond briefly to your presentation. Currently, even as we meet today, there is a constituent assembly in session in Chile writing a new constitution for Chile. And they are writing this new constitution under a constitutional amendment to the Chilean constitution that was enacted in 2019 that commands the Constituent Assembly to comply with international law. So that would fall, Richard, under your second typology, like Switzerland, constraining how constituent assemblies can act. But the debates around that in Chile have shown that to say that is kind of meaningless, and it really just opens the ground for more debate. So there's a question in Chile, the right says, well, that means the Constituent Assembly has to respect all the existing free trade agreements and international economic law commitments that have already been made, and that has to shape the new Constitution. The left says, no, human rights is really what it refers to, and we have to think about the International Covenant on Economic, Social, and Cultural Rights as being, you know, the backbone of the Constitution. So there's a way in which international law is too broad a category. And I wonder if there's other concepts from international law, Richard, that might help refine your typology and be useful in that analysis. And similarly with Elizabeth, I wonder if there's a way in which the dialogic approach seems a very broad concept too, and can lead to, it's not really a method, right? Like sometimes we speak of a comparative law method. It seems like there's too little constraints on this idea of dialogue, and it can just lead to great discretion and cherry picking. And I wonder if there's categories from the field of international law or comparative law and that tradition that might constrain it and give it a little more meat. So ultimately, I'm just trying to get everyone to think more deeply. You've already done a great job doing so, but more deeply across these different traditions and see how they can nourish each other. Thank you.
Alex, thank you for the very provocative, I think provocative questions. So for our panelists, I suppose that you can respond briefly if you would like to. I would invite you to, if you do, and then we can move to soliciting questions from the audience. I don't know who wants to start. I can just call on the order I see you. Kurt, do you have any thoughts?
Oh, sure. I just briefly, and partly just maybe to also tee up possible questions. I do think it's absolutely right, as Alex was suggesting. There is a resort almost inevitably to kind of traditional classifications. I was just writing down as Alex was talking, civil versus common law, Commonwealth versus non-Commonwealth. She mentioned democracies versus non-democracies or authoritarian regimes. One thing we didn't mention, federal versus non-federal systems. That's actually kind of a big distinction in this area that's not always appreciated about how significant it is. You know, presidential versus parliamentary, obviously a huge potential. And the reason these distinctions, I think, get deployed, one is to try to understand possibly why we might see the variations we're seeing, but also a cautionary note, and I think Mila also touched on this, watching out for things that seem similar but might not be once we realize there might be some different kinds of classification. I think all of these need to be approached with some caution, but it's almost inevitable. I think we will try to understand what we're seeing in part through those classifications that Alex mentioned.
Richard, do you have any brief responses to Alex's challenge to you?
I do, yeah. Thank you, and thanks again, Alex, for that really important questions you're putting to all of us, and thanks for the one you put to me. On the Chilean case, just very briefly, you mentioned that the Constituent Assembly is said to be bound by international law. And in thinking about how to respond to your question, I want to refer to one of Mila's many important points, which is what counts as international law, and how do we identify what those commitments are that are binding on in Chile in the Constituent Assembly. We can refer to the US founding moment for some insights into this, although it's certainly not going to bind anything that happens in Chile. But there was a violation of rules put on the Constituent Assembly. They broke the rules of constitutional creation in 1787, but those violations of the rules were retrospectively validated by these extraordinary gatherings of conventions in the states. And so I use that insight to think about what the Chilean case is confronting us with right now, which is you have a claim that you're bound by international law. Okay, well, what if they violate international law? Will that make the Constitution unconstitutional? I think it will depend on how the Constitution is ratified. It's going to be ratified in a referendum, and using the same the precedent from the United States in 1787 that if it is validated by a popular vote, that we can retrospectively legitimate it in a certain way, sociologically. Now, whether it will be legitimated morally is a different question. But if you do want to put in the primary position at the very top of the hierarchy, popular ratification, popular consent, then that will be the answer in Chile. If the people accept the Constitution, whether or not international law has been respected, it will be seen as sociologically legitimate. But that may not be the standard that we want to appeal to. We may want to appeal to a higher level of legitimacy, moral legitimacy.
Elizabeth, do you have any thoughts you'd like to offer on the sort of the challenges or barriers to using comparative law for the purposes of international legal scholarship?
Yes, thank you very much. And thank you, Alex, for your very thoughtful comments. So I think that your question related to me and the sort of the lack of constraints or the worry of lack of constraints of the dialogical approach is well, I hear that critique. And I think it also goes to the heart of the resistance of, at least in the context of international trade tribunals, to expand their reach beyond trade adjudication. And this has also been criticized, obviously, by international human rights groups, environmental groups, for having that constraint. And so they're sort of caught in the middle of this difficult polemic where they're dealing with a very narrow field that has huge impacts, right? It has huge impacts on the ability of domestic institutions to pass regulations and laws that serve the public, to create social policy space. And so I find that, at least in the way I've used the dialogical approach, is to just help understand ways in which the trade tribunals have engaged with non-trade norms. Now, to use it as a methodology, absolutely, it's not really a methodology. But I think for many scholars that have contemplated the dialogical approach in international tribunals and the way they talk to one another or borrow from each other's norms or look to each other's legal jurisprudence or regimes, I think what it does do is allow for not only judicial comity, but some understanding or immersion of universal guiding principles. And I think for us to have a real sustainable development future, there needs to be more conversation between areas of trade and areas of environmental regulation, for example. And how do we do that is the big question, particularly when language is one of the constraining factors. They speak very different languages, and the jurisprudence, the goals of the jurisprudence is quite different, but there are ways in which to reconcile them. So I think, just to sort of Mila's point about methodological matters and the introduction of social sciences, I think to some extent we have to create categories of analysis and look at specific areas in which, and decide what questions we want to ask, at least in this field of trade and environment and sustainability, and what goal we're trying to reach, and how we can borrow from the various regimes to create universal guiding principles so that there's some kind of shared governance between trade and the environment. So I'm just looking at a very narrow field, but I think that this might apply in other areas, like as you know very well, in human rights, and how it has expanded in various aspects of international law.
Mila, I'll give you the last spot to respond before we move on to our first hand that has been raised.
I can be brief. So I think of myself as working in comparative constitutional law / comparative law. Then I dabble a little bit in international law. I wouldn't exactly call myself an international legal scholar, but then at the same time, I also work in the social sciences. So trying to combine all of these can be a challenge. So I always try to ask myself, what would the comparative lawyers say? They're usually my critics, because I try to quantify things, and it turns out there is always more nuance and more difference to be seen. And then I will try harder, but then at the same time, like, okay, but it's really hard to create all this data. And of course it has limitations, but but I try. But for example, if you work with large N data, you almost always see that there's legal families, right? And then of course you can start deconstructing these families, but at very general level, there always are, including with this project I was just talking about. But then if I go in a room with social scientists, I just to share that, and I try to bring some of the insights from comparative law, more traditional comparative law scholarship, the first thing that they will say is that's not methods, right? What are we talking about here? Let's get lost in translation, because what comparativists call methods is not what social scientists call methods. We're talking about very different things. They would maybe say these are approaches to comparison. They're not methods to doing comparison. So I don't know, I'm always confused. That's my takeaway.
So we have about 15, 18 minutes for questions from the audience. Please just raise your hand, and if you could keep your questions or comments short and focused, we can get through at least a few of them. And so the first hand I see is Margaret Wu. Could you please unmute yourself?
Yes, thank you. Hi, and I have to apologize. Actually, I'm going to have to run to teach. So part of attending a conference virtually has its limits. But I was wondering if the speakers can comment on comparability. Because, and the idea of comparing apples with oranges, and whether we should only compare legal systems with similar values. And the only reason why I'm raising this question is that the recent Supreme Court case right now before the court challenging Roe v. Wade has two comparative law positions. One saying that, Roe v. Wade is consistent with the rest of the world, and the other says no. And so, it really does, again, bring forth the difficulty of comparativists. That is, what is comparable? And I don't know if any of you have a position on that.
Maybe we can collect questions if anyone else wants to raise their hand and add a couple. And if not, we'll just go to the panel with Margaret's question. Going once, going twice. Okay, panelists.
I can say I have something to say in response to that question. I mean, so I'm actually part of one of the briefs, and I think it's actually a truly fascinating example that shows the difficulties of comparison, right? So the one brief, mostly written and signed by male law professors, let me just make this clear, says if the US is an outlier, most countries have much shorter limits to have an abortion, and they're right. Technically, if you only look at what's written on paper, right? And then there is the second brief signed exclusively by female law professors that says that actually, if we look at what other countries do, there's these many, many exceptions. So yes, sure, technically they have a shorter time period to have an unconstrained abortion, but then there are so many exceptions that there effectively are where the US is, right? So it's a difference between a formalist or a comparison by the columns only approach and a functionalist approach, I think. And neither of them are deep cultural approaches, but I guess they do reflect what's at stake by some of the traditional comparative law debates. If you only look at written text versus are you also looking for functional equivalents, right? Like these exceptions to the rule as opposed to merely the basic rule, I think it's.
Other thoughts from the panelists on Margaret's question? And please with the audience, please raise your hand or type in the chat if you would like to join the conversation.
I'm happy to add a quick comment on top of what Mila said. I do think the question, it's a really good question. It highlights something I just briefly touched on, which is, I realize in working in this area, you really need to keep some eye on the purpose of the inquiry of this comparative gathering information. And the questioner, I think the question highlights an assumption which might be true or might not be true, but it's worth surfacing, which is particularly in the rights area. It's come up in the US Supreme Court in a number of cases, like on the death penalty, that if you look at a certain set of comparisons, you'd have to decide what those are, that there's some kind of almost a natural law faith that we will see over time kind of an evolution towards better rights, a kind of a progressive realization of human rights. And that if that's true, you'd have to figure out like which are the countries likely to be reflecting that development, assuming you think it's true at all. Of course, that strikes me as a highly contestable proposition where we might actually see it's politically contingent, and there's what we would call retrenchments. And of course, we're making assumptions about what progressive means in that context. And that's, you know, the Supreme Court itself has debated that implicitly about how much they ought to on a lot of Western countries have gotten rid of the death penalty or something, and whether that should inform the United States, and maybe it should. But a different way it might be relevant, and maybe it could, maybe for abortion, maybe for death, lots of issues, is not necessarily the kind of human rights normativity per se, but sometimes questions of workability. If there are really questions about, I'll just make one up, whether a certain time period for abortion still allows a vast majority of women to have freedom of choice, you know, one could debate these kind of workability and practice questions. It might be that seeing different systems and how they've implemented different time periods has really played out as a workability question, as opposed to this big kind of natural law question. Then I think there are lots of projects, and Mila's done some of them that are terrific, that are much more, I think, sometimes agnostic about the norms, and sort of more of an outside studier of how things move across boundaries and how they are developing, and leave it to other moral philosophers or others to make some of these normative questions. But I really think thinking about the purpose of the inquiry is useful.
I'll just say one word if I could, Jason, unless you were going to say something.
No, please, go ahead.
Yeah, it's really going to be a fascinating case, isn't it? I suspect that some of the court will be moved by what happens around the world, but some just will not be, right? Think of the Scalian view, which is, well, no, the United States is exceptional, and what happens here is what happens here, irrespective of what happens elsewhere. There was a proposal about 10 years ago to create an international constitutional court. I wonder if any of you are aware of this. And, you know, what would the International Constitutional Court propose 10 years ago at a conference in Tunisia? How would it have ruled in the face of this challenge in the United States context? Is there an international law on the right to procure an abortion? Which of the two briefs would have been more compelling to that court? So it's one thing to have an American court answering this question about its own law, but quite another, I think, for an international body authorized to make such a decision, interpreting US law and practices from its third-party neutral perspective. Very, very interesting, I think, to think about.
John, your hand is up. Please unmute and ask your question.
Yes, thank you. John writes. Oh, here, my camera's shut too. I wanted to, first of all, I'd really like to thank the panelists and indeed the whole, Jason and the whole staff at Wisconsin for this really interesting first session. I think the whole conference looks like it's going to be very interesting, but I thought the first presentations were just excellent. I really appreciate all of them. I wanted to suggest a little different direction for my question. You've all been talking about differences, and I like differences. I've always been motivated by studying differences myself. But I think comparative law can also be focused on similarities, as several of you have mentioned. And I just wondered, but there hasn't been any much discussion about use of comparative technique to really work out similarities. I suppose that's partly because we're all a little tired of the harmonization of law projects that have dominated the first part of my career anyway. But I wonder if there are any thoughts about that. You know, in international law, there's this notion that a source of international law are the comparative, the common principles of law in different traditions. And I know that tends to be my view has been that's always been rather limited because there just aren't that many principles that deal with really cutting edge problems today. It seems to me. That you can show are common to lots of. There's so much, so much room for debate about a lot of these things. But I wondered if that search for commonality is also part of the project here by the use of comparative law in international law. Thank you.
I'll just open it up for our last few minutes here for you guys to speak up if you have any thoughts, and I'll wait to see if there are any more hands.
You want me to, shall I say something?
Of course, yeah. I'll call on you. That's easier. Mila, please.
I think it's a very interesting question. I think that others may correct me if I'm wrong, but that for international lawyers, the natural inclination is to look for similarities and not for differences. So the whole promise of, or the premise of customary international law, right, is if enough states do something, then everybody else is bound too, right? And we don't care about your differences anymore unless you're persistently objected to it. But we do, you know, so I think we're generally inclined to as international lawyers to look for the similarities. I mean, that's what we want. We want one international legal system to govern all, or at least the same rules to govern everybody, right? To say that international law is about differences is an odd thing to say for a group of international legal scholars. So I do think when we're thinking about the comparative enterprise, we should be pushed to be looked for the differences and not the similarities.
Yeah, Elizabeth.
Yes, hi. Thank you, John, for that interesting question. So I wonder, though, is international law really looking for similarities all the time? Or is it are we sort of moving into a world where we're trying to manage plurality? And so my question is, how does comparative law deal with that? We have a plurality of systems, both in international law, various regimes, various international rules that apply in different ways, depending on what the area is. And then, of course, we have a plurality of national law systems. But I think the international law project, to some extent, maybe original in its origins, was to create similarities and overarching guiding principles. But I think more and more has moved towards some kind of management of plurality. I think the European Union has been an example of that. I think the European Court of Human Rights and the way it tries to manage sort of through various, marginality and other types of judicial techniques to try to manage that plurality. So I guess I answer your question with a question, which is, is it really about similarity? Yeah, like you said, many of us are a little tired of harmonization. That's been very sort of relevant in the area of trade and regulation, for example. But it's really about convergence as well as plurality. And so how does comparative law deal with that today?
It's a fascinating point that you've made, Elizabeth, and I wonder whether you're getting at maybe the public relations component in international law, where let's say you have a given multinational, multilateral organization that sees a certain value in claiming there to be convergence when really there is not. So, think about the doctrine of the margin of appreciation in the European Union context. Well, that's a recognition that the member states will do things differently, but consistent with some underlying, some overriding value. The implementation of that norm or value may differ, but there's still a commitment to this higher ordered norm or value. But that may just paper over some quite meaningful differences when it comes to how the member states are operating. And here I'm thinking of a great book that I read in 2010 by Claudia Haupt, who's a member of the ASCL, by the way. I don't know if she's here today. But her book was about the concept of neutrality in law and religion. And she compared how neutrality is put into practice in the US versus Germany. Both states, both orders, they commit to neutrality, but they put it into practice in such a way that there's actually a strong conflict between the two countries in how they determine and apply what neutrality means on the ground. And so I wonder, Elizabeth, your point really raises for me the question about the public relations component here, international law, and the move and the striving for convergence.
Can I maybe say something else if nobody else is? So one, I think in these discussions, it may be useful, and I may have been a bit fluffy in my own presentation here, is to distinguish between comparison at the international level, right? International law has done that for a while under the heading of fragmentation, right? We've said that like there's different parts of the international legal system that do with the same thing, and they sometimes reach similar different outcomes. So that's one potential part of the inquiry for discussion at this conference, I guess, but international law has been doing that for a while. I think the more, I mean, maybe the part that I'm interested in is that, like, do we allow for different national stances or different national interpretations, or once we start comparing between the international and the national, right? When we're looking for whether what seems to be the same is not actually the same when you look at different legal systems. So I think it may be useful to think about whether it matters, whether we're doing comparison between parts of the international legal order at the international level, or whether we're looking a level down at national legal systems and all the complications that brings with it.
It strikes me that Elizabeth's comment at least implicitly recognizes two different kinds of comparative international law. And so we have it as an academic exercise, which I think is perhaps how Kurt and Mila's projects are addressing it. But I think in international trade, there's a practice-oriented concern, which is the ability of members of the dispute settlement body, the appellate body, that sort of thing, to actually sort of, accurately understand the law that comes from other international legal systems. And so I guess I wonder if any of you have any brief comments on that sort of capacity problem from the perspective of practitioners of international law. Any thoughts? No?
I don't know anything about practice. Sorry, not the right.
Elizabeth, you know something about practice. Do you trust the appellate body to actually properly understand international environmental law?
Oh, Jason, we're being recorded. Well, no. So it's an interesting point. And I think that if we only look at the trade regime, we've seen an evolution of the trade regime, right? From one that is very much practice oriented and very technical to one that has become more fluid, more organic, one more willing to engage with other principles of international law in other regimes. And the study and the scholarship, as you know, in trade law has evolved, right? Has become much less about the practice and more about the academic engagement and scholarly aspects of trade and its impacts on administrative law and, and domestic law and so forth. So I think we're at a turning point, at least in trade, and probably in investment as well. You could speak more to this. In that investment, we see more of sort of this desire towards having some kind of universality of norms, right, on how to deal with investment questions through an appellate court proposals and things like this. Whereas trade, which has accomplished that, is moving away from that, maybe not from its own accord, not because it wants to, but because some nations seem to want that really have a say in the trade regime, which of course then brings up the aspects of the political aspects and the diplomacy, foreign relations aspects of international institutions like the WTO and others. So I in practice, and I really I find that from a practical perspective, perhaps the regional trade tribunals and investment tribunals are more helpful to regional parties that engage with those tribunals. I think that they have looked to international trade law, the WTO jurisprudence for guidance on how to interpret treaty provisions under the regional arenas. But I think that the regional panels have made important decisions that have really impacted, questions around tariffs, questions around anti-dumping and subsidies, as has the WTO. I don't want to take it away from the WTO, but I think in terms of, a regular sort of practitioner on the ground. But again, like Mila, I'm not a practitioner of international trade, so I can't really, I'm sure there are some out in the audience that could speak more to that question than I can, but those are some of my thoughts.
We have one hand up, but we're from Howard Schwaber, my colleague here, but we're out of time and I was told to end on time. to give us a half hour to go eat lunch before the next session. Howard, I'm sorry. Don't be upset with me. And so I want to thank the panelists. Please give them a round of air applause. Thank you for a really fascinating and invigorating starting panel. Maximo, do you have any last words that we need to tell folks?
No, not really. Thank you for that excellent panel. I guess, Jason, you are the main organizer here. So in terms of, the next event coming is the,
yep.
Right, that
you'll have to click on the
panels, concurrent panels, right, at 12:15 Central Time.
Yep.
Right, we have 5 very, very fascinating concurrent panels coming. Thank you so much for those excellent presentations, those excellent comments, Alex, that excellent moderation, Jason, and I'm looking forward to the rest of the conference.
Great, thank you, everyone. We'll see you in the other panels. Bye-bye.
Bye.